viewers, in the Supreme Court today, the Muslim side tried and tried and tried. They said the 1991 Places of Worship Act is being violated completely, that it forbids the conduct of a survey in the Gyanvapi Mosque. They said the trial court has run amok. They said that the survey reports were leaked to vitiate the atmosphere and create a narrative. They said, viewers, that the courts were collaborating with the Hindu side, and for that reason, an immediate express stay must be placed on all proceedings in the lower courts, in the Varanasi courts. They said for this reason, the survey also should be stopped. But 1 hour after the hearing began, the Supreme Court did not stay the survey. They in fact left it to a district court to look into the matter. Even the decision to hand this matter to a more experienced judge was with a caveat. The Supreme Court said and made very clear, viewers, that their decision to take this matter and give it to a more experienced district judge was not a reflection on the competence, the impartiality of the judge who is currently hearing the matter. The Supreme Court said that this was a complex issue, and therefore a judge with a little more experience would be better served in addressing the demand seeking the right to worship for Hindus at the mosque. In a sense, viewers, the Apex Court virtually ruled that Hindu groups cannot be barred from ascertaining the religious character of a place of worship, even though the 1991 Act, the Places of Worship Act, the Muslim side said, stands in the way. In fact, it can be said that the highest court of our land has decided not to intervene in the matter substantially. Even after 3 centuries since Aurangzeb allegedly destroyed the mandir, the Astha of Hindus has never wavered. Viewers, till 1992, Hindus offered daily prayers at this disputed site and structure. Today, naturally, viewers, given the fact that their petition was not in any way, or at least their case was not in any way thrown out by the Supreme Court, and in fact the pleas of the Muslims were not taken on board, they are claiming vindication. They are saying that truth and Astha, their belief that is, has triumphed. Listen in, viewers. We had, just a short while back, and I'm going to try and pull that out, the bite of the principal plaintiff in this case, Vishnu Jain. I'll come to that. But viewers, let me just quickly give you some of the takeaways from the Apex Court's order. First takeaway, the Supreme Court refuses in a sense to intervene. It leaves this matter for the lower court to decide, take it to its logical conclusion. Second takeaway, the Muslim side's pleas in substance were rejected. No stay on the Gyanvapi survey has been put. So that's takeaway 3. Takeaway 4, case given to the district judge, not because the trial court judge was incompetent, inexperienced, impartial, but because a case of this complexity sometimes requires someone with more experience, and a district judge usually has, as the court itself said, 20 to 30 years of experience. The interim arrangements, that is the last order that was passed by the Supreme Court, stays. So, viewers, the shivling, the controversial shivling that you're seeing on your screens will continue to be shielded by security, while namazis will get access and will be able to pray at the mosque. The 6th takeaway, the 1991 law will not be a bar, at least as of today, viewers, in the conduct of the survey. Now, this is fundamentally important. As the Supreme Court refused to put a stay on the Gyanvapi survey, this is what it observed regarding the Places of Worship Act of 1991, and I want us to now read this together. The Supreme Court said the hybrid nature of places of worship is not unknown in India, that there are many such mosques that are built upon destroyed temples. It went on to say, ascertainment of religious character of a place is not a violation of the 1991 Act, viewers. It went on to say the ascertainment of religious character may not necessarily fall foul of Section 3 of the 1991 Act. While the suit now lies, viewers, in the domain of the district judge, the MIM's Asaduddin Owaisi has come out and expressed his disappointment with the Supreme Court, thereby implying, perhaps, I don't know, that the court didn't do enough to protect Muslim interests in this particular matter, and that he goes on to say he's upset that the lower courts are collaborating with the Hindu side. These are his words, not mine, and I will play them out for you. Let's listen into Asaduddin Owaisi.
My disappointment is on this issue that I was expecting that the Supreme Court will nip it in its bud, because this whole 91 Act categorically states that this Act was made so that future controversies don't arise. So on that part, I was expecting the Supreme Court would nip it in its bud, because lower court honorable judge was listening to one side of what the petitioners were coming and telling him.
On the other hand, viewers, the Hindu side claims vindication. Listen to this.
जो आपने एक्सटेंशन ऑफ सर्वे भी मांगा था जी, एक्सटेंशन ऑफ सर्वे भी जो मांगा गया था, उन चीजों पे क्या एग्जैक्टली डिसाइड होगा?
एक्सटेंशन ऑफ सर्वे अभी हमने जो मांगा था वो कोर्ट वहाँ डिस्ट्रिक्ट जज डिसाइड करेगा,
वो डिसाइड
करेंगे। अभी सारी चीजें डिस्ट्रिक्ट जज वाराणसी के सामने हैं, और कोर्ट ने ये भी कहा कि जो सिविल जज सीनियर डिवीजन है, हम उनकी कॉम्पिटेंस पे कोई कमेंट नहीं कर रहे हैं। हम सिर्फ ये चाहते हैं कि ये सेंसिटिव मैटर है, ये एक सीनियर जुडिशियल ऑफिसर देखे। वजू के लिए अरेंजमेंट किया जाएगा। चौथी बात, जो मुस्लिम पक्ष की एप्लीकेशन 11 की और प्लेसेस ऑफ वर्शिप एक्ट के आर्गुमेंट्स, वो भी डिस्ट्रिक्ट जज साहब देखेंगे। यही आज सुप्रीम कोर्ट का ऑर्डर है, उस एसएलपी को पेंडिंग रख के इसको 2 हफ्ते बाद लगेगा। 8 हफ्ते इंटरिम ऑर्डर कंटिन्यू किया गया है। अब जब इंटरिम ऑर्डर कंटिन्यू रहेगा तो कोर्ट ने कहा जो भी ऑर्डर पास होगा, जो हमारा इंटरिम अरेंजमेंट है वो कंटिन्यू रहेगा।
Viewers, let's open this up straight away for debate tonight. Let's go straight across first to Advocate Talha Aamir Rashidi, Zeba Yasmin, and Tausifur Rahman and others. I want to first begin with Advocate Talha Aamir Rashidi. No stay on the survey, sir. No dismissal of the Hindu side's case. No, absolutely no interference by the Supreme Court in this entire issue. I want to ask you a basic question. It's quite clear that Hindu Astha cannot be shackled. Why are you standing still in the way of the truth? Allow the Hindus to worship there. Survey की report तो हमें सबको पता ही है. We know what the survey reports are saying. The shivling has been discovered, and we are not just talking about the one in the Wazoo, which is being claimed as a shivling, but we are talking about, sir, the shivling that we see in the complex. We are seeing the damrus, we are seeing the trishuls, we are seeing other motifs which are intrinsically associated with Hindu temple architecture. Why are you denying? Why are you today, sir, punishing Hindus for their belief? This is the question. आप हिंदुओं को उनकी आस्था के लिए पनिश क्यों कर रहे हैं? जिद छोड़िए.
Once again, the most important question here is that what wants to be supreme, Astha or the law or the constitution, the justice, the system of the justice? Do you want the Astha to be supreme? Do you want the country to be run by the Astha of the majority of the Bahusanchak Samaj? That is what that you want. The Supreme Court has not outrightly rejected the plea of the Masjid Committee. The Supreme Court has transferred the court from the senior civil judge to the district court. You can assume and you can presume the reason behind that. I don't want to comment upon the Supreme Court's observation. The Supreme Court has directed the district court to finalize the petition under the Order 7 Rule 11 at priority on a priority basis. The Supreme Court has directed the DM to resolve the issue of Wuzu Khana on a priority basis. What do you think about this? The country has to run as per the law. The country will run as per the constitution. Our primary plea was that the survey commission should be stopped. But because the survey has already been concluded...
No. You said that the survey should be stopped because the 1991 Act prevents from... No, sir, I'm not going to just let you say whatever you want to say tonight. आपके जो prime... नहीं, 1 minute, sir. MIM के जो big boss हैं, MIM के जो big boss हैं, ओवैसी साहब, वो खुद disappointed हैं. और आप कह रहे हैं कि सुप्रीम कोर्ट ने आप पे मेहरबानी की है.
बात पूरी होने दीजिए, आप फिर कह रहिएगा, निकालिएगा. मैं वही
सर, आप गलत बात भी बोल दीजिए, कोई प्रॉब्लम नहीं.
सर ठीक है, बोलने दीजिए ना, आप गलत को गलत कहिएगा, बोल तो लेने दीजिए. आप बोलने पे भी आजादी नहीं है क्या?
बोलिए सर.
आपकी आस्था बोलने की हमारी आवाज को भी रोक देगी क्या बोलने से आपकी आस्था?
चलिए बोलिए.
ठीक है, आप मेजॉरिटी में, आप बहुसंख्यक समाज में, आपकी आस्था...
Don't play the victim card. Don't play the victim card, sir. No one plays the victim card, please.
I understand that you have that majoritarian privilege. Let me complete. Let me speak out. बोल तो लेने दीजिए, हमारा दर्द बयान तो कर लेने दीजिए, उसकी भी आजादी नहीं देंगे. अब सुनिए, मैं ये कह रहा हूँ, मेरी प्राइमरी प्ली मस्जिद कमेटी की प्राइमरी प्ली ये थी कि कमीशन को रोक दिया जाए. अब चूंकि कमीशन का काम पूरा हो गया, उसने अपनी रिपोर्ट सबमिट कर दी है, तो उसके बाद सुनिए बात पूरी होने दीजिए. सुप्रीम कोर्ट ने ये कहा कि कमीशन को आप किस ग्राउंड पर रोकना चाहते हैं. हमारा ग्राउंड ये था कि प्लेसेस ऑफ वर्शिप एक्ट 1991 ये कहती है, उसका सेक्शन 4 क्लॉज 2 ये साफ तौर पे कहता है कि नो लॉ सूट, नो लीगल प्रोसीडिंग्स शुड बी अलाउड इन दीज मैटर्स ऑफ सच वर्शिप प्लेसेस. हम ये कहते हैं उसके तहत कोई भी लॉ सूट चलेगा ही नहीं. हम अब भी उस बात पे कायम है. चूंकि हमने एक एप्लीकेशन आपके डिस्ट्रिक्ट जो सिविल कोर्ट थे वहां पे डाला था, सिविल कोर्ट ने उसे एंटरटेन नहीं किया, उसका डिस्पोजल नहीं किया, डायरेक्ट डायरेक्शन दे दिया. तो सुप्रीम कोर्ट ने यही कहा है डिस्ट्रिक्ट कोर्ट से डीएम का केस ट्रांसफर करके कि जो रूल 7...
ठीक है, हमें पता है सर, मैंने पूरी कहानी समझा दी है. आपका एक छोटा पॉइंट,
तो हमारी बात, तो हमारी जो प्ली था, हमारा जो मोटिव था, सुप्रीम कोर्ट ने पूरा कर दिया.
अच्छा, पूरा कर दिया. तो ओवैसी साहब की जरा आप सुन लीजिए, वो कितने खफा हैं. लेट्स प्ले आउट मिस्टर असदुद्दीन ओवैसी, who calls himself a barrister at law at Lincoln's in London. That's where he's done his law, he says, and that qualifies him to be an expert on the law. He is disappointed, viewers, today, saying that he was hoping that the Supreme Court would nip this entire issue in the bud,
yes,
because of the grounds that Mr. Ahmedi argued. But here you have, just to prolong the agony for the Hindus, you have Talha Aamir, who is trying to suggest that their pleas have been heard. Now, viewers, let me tell you, had there been a stop on this survey, the same group would have come out and claimed vindication. Said, dekhiye, we are absolutely right. Dekhiye, the Hindu side was trying to whip up a communal frenzy. Dekhiye, the Hindu side doesn't respect the law of the land. Today, viewers, their claims have been rejected, yet there are some who will not accept and see the writing on the wall. They will not concede the space. They will not allow the other side to have its way. They are pushing for a face-off, viewers. And then they talk about majoritarianism. Majoritarianism तो ये है, जब कोर्ट ने आपको रिलीफ भी नहीं दी, तभी भी आप standing in the way. That is majoritarianism, viewers, in a different sort of way. Let me first play out what Asaduddin Owaisi said, in case you have forgotten. And let Mr. Talha Aamir also listen to this. Suniye.
My disappointment is on this issue that I was expecting that the Supreme Court will nip it in its bud, because this whole 91 Act categorically states that this act was made so that future controversies don't arise. So on that part, I was expecting the Supreme Court would nip it in its bud, because lower court honorable judge was listening to one side of what the petitioners were coming and telling him.
Viewers, that is the truth. At least Mr. Owaisi is telling the truth to some amount. Rizwan Ahmed, who is an advocate and a lawyer, is also here with us. Ishkaran Bhandari. First lawyers to lawyers. 1 minute, please. Let me bring in Rizwan Ahmed. Rizwan Saab, Talha Aamir says, "Hamari sari baat maan di. We have come out vindicated from this." Is this a fact, sir? And to what extent?
Thank you so much, Jain Vande Mataram. For convenience of all, I will use English. At one place you were wrong, Rahul, when you said that he's a barrister from England or somewhere. Always remember one thing. Chartered accountant and lawyer are the two degrees. If you do from country A and you go to country B, you become redundant. Ambedkar ji and Gandhi ji came to India and they were LLB from India also. Asaduddin did not do LLB from India. That is why he is such an idiot, such a joker as far as law is concerned. Number one. Number two, I wish I could make a compilation of his flawed and his failed prediction about law from triple talaq to hijab to 370 to blah blah blah. I think there are a dozen cases where he has failed as a lawyer.
He is a member of parliament of the world's largest democracy. And
Number two.
An XYZ person who has no introduction.
Sir, in this country, they call the Prime Minister of India. Do you know what they call him? Should I list out some of the names? तब तो आपको गर्मी नहीं लगती.
जो बोलता है
नहीं, तब तो आपको कोई डिच नहीं लगती. Then you don't feel, then you don't feel that something is being denigrated. He's only called him a joker, sir. That is his prerogative.
तो ठीक है.
My dear child,
he feels that way. He has not abused him.
I am talking about a lawyer, not a member of parliament.
Now, I can't stop a person. If I
child,
stop anybody from saying something, then you will accuse me of being undemocratic.
Number three.
Damned if you do, damned if you don't.
Three.
I don't understand what to do sometimes. आप लोग इंटरप्ट करते हैं, मैं आपका फेडर डाउन करूं, आप बोले देखे बोलने नहीं देता.
People,
मैकएडम्स का आदमी है. अब मैं क्या बताऊं?
These people, Rahul, they don't have an iota of common sense, an iota of common sense. In a criminal proceeding, during the proceeding, you can keep changing the sections as and what the evidences arrive. In a civil proceeding, you make a plaint, you make a petition, and the court listens to that petition only. The moment you change your prayer, you have to come with another petition which will be listened in that backdrop and dismissed or allowed. For God's sake, these lawyers, oh my goodness, from where he did his barristery, I will never send my child to become a barrister. He does not understand the basic thing of law, that this petition is not to change the character of the place of worship, for God's sake. This petition is for a relief X. To change the character of the place is relief Y. On the basis of the evidences generated in this survey, the Hindu party might in the future come up with a new plaint, a new petition, where the prayer will be that this is not a mosque but a mandir and should be handed over to the Muslims. At that stage, this great member of parliament, this barrister, should start talking about 91. He does not know when to put an argument. He is putting a premature argument. And the person, Talha, sitting over here, he is giving me a lecture how to support a member of parliament. Yes, I say, in Indian democracy, idiots are reaching the parliament. And so is this barrister, whom I call Barrister-e-Jahiliya. Understand? Now go and do whatever you want to do.
Is that what you mean to say? Our Prime Minister is also a member of parliament. Is that what you mean to say? You are calling him names.
Okay, Talha Aamir, don't change the subject.
Our democracy is a witness to the fact that criminals have reached the member
I
of
don't
the
underscore. 1 minute,
parliament.
please. I just want to be very clear. I just want to be very clear about one thing. Amir Saab, 1 minute, or jo Rizwan Saab hai, 1 minute. Listen to me. I don't hear. Look, I can't stop you from saying what you want to say on live TV. I don't have a button that predicts your thoughts. All I can say is I don't underscore any of the personal abuses or jibes that are being made. You are free to make them. It's more a comment on your own arguments, not on me or the channel. I can't stop you. I can only say that let's keep it above board. Let's not get personal. The person is not even here to defend himself. But chalo, bol diya. I don't agree with it. The channel doesn't endorse these views. There is a caveat that I put out. This is very important, viewers. But I cannot stop you people from saying what you want to unless you are pushing the boundaries of decency. And when you do that, then I have to stop you because I'm called upon by the Ministry of NB, their rules to not allow indecency. Now, Ishkaran Bhandari, I just want to ask you this question. The relief has not been given. I'm coming to you, Nupurji. I'm coming to the political debate. I just want to get the legal debate out of the way. Trust me on this. Ishkaran Bhandari, I just want to ask you a simple question tonight, and this is an important one. If no relief has been given, what is stopping now the masjid side from saying, okay, come and pray. We will give you back the rights that were taken away from you all the way up to 1992. Inka kya jata hai? Will it change something on the ground legally, Ishkaran Bhandari?
Rahul, on your debate with Varit, I think 1991, I said this act will not apply in this case. It will not prevent the right of Hindus. He kept quoting some Ram Janambhoomi judgment paragraph, and I kept telling him, please understand the difference between obiter and what is decided by the court. That was not a central part of the dispute. You can play that clip, that is very clear. And now Mr. Owaisi himself, in a way, has admitted that that act has not been applied by the Honorable Supreme Court because it was very obvious it could not be applied in this. Secondly, they had a very specific release. They wanted that for 500 years, they have used the wuzu khana, and in the manner they have used the wuzu khana, they should be able to use it. The court has not given. The court has continued with the interim arrangement that the Honorable Supreme Court made in the last date of hearing. So it is very clear that they have not won anything from the court. What they win in future under Order 7, Rule 11, rejection of plaint, what they don't win, we'll have to see in subsequent hearings. But one big question we have to ask, because majoritarism has been used, victim card has been played.
Yes.
Majoritarism is in where the Hindu population falls by more than 20 percentage points, where in Pakistan it falls to nothing, where in Afghanistan it is over. That is majoritism. And in independent India, we have to ask this question, that if it is proved that a temple was destroyed by a religious bigot in power, what do we in independent India do? And how do we compensate and how do we ensure justice? This is a question we as a civilization have to ask ourselves all over the world. For example, in US, people who were indulging in slavery, slavers, no matter how prominent they were, their statues are broken down today, even though they were founding fathers of US. So we as a civilization have to ask ourselves the question that if it is proved that a barbarian broke the most holy places, how do we ensure justice?
I want to go straight across to Padmaja Joshi, who has with her now the order copy, and it will be fascinating to read through the order copy because all these people who are making fake claims here on national TV will be exposed. Padmaja Joshi, over to you.
All right, the big takeaways over here, the Supreme Court has today given basically 4 instructions. They have said that the civil suit shall stand transferred from the file of the civil judge senior division to the court of the district judge. That is, all the petitions which were being heard by the civil judge will now be heard by the district judge. Second, the petition filed by the petitioner under Order 7, Rule 11 of the Code of Civil Procedure shall be decided on priority by district judge. Now, what does this Order 7, Rule 11 mean? Which is that when the Muslim side says that the maintainability of the petition which has been filed by the Hindu side has been challenged, that is what will be decided on priority by the district judge as soon as the transfer happens. Since parties are appearing on notice, all orders in the suit shall be passed upon hearing. The interim, so all parties will be heard now by the district judge, and as far as the order on the maintainability of the survey is concerned, that will be heard on priority. What was said on the 17th of May by Supreme Court shall go on for a period of 8 weeks so as to enable any party which is aggrieved by the order of district judge to pursue its rights and remedies in accordance with law, which means that for a period of 8 weeks, the wuzu khana shall be fenced off. The shivling will, what is claimed as shivling will be protected, and also the namazi should not be hampered. This will be it will be in effect for a period of 8 weeks, and it finally says, unless adequate arrangements for ensuring due observance of wuzu have already been made by DM, we direct the DM in consultation with parties to ensure that appropriate arrangements are made for the religious observance, and the order passed by Civil Judge Senior Division Varanasi on 16 May shall stand subsumed by terms of the order of this court dated 17 May 2022 pending further orders. So that is as far
so,
the Supreme Court has
let's
said.
just be clear about this. Let's just be clear about this. There is no reference here, no reference whatsoever to this 1991 law, which today was trying to be forced into the equation by Mr. Ahmadi to suggest that this entire survey was illegal, ultra-virus of Parliament Act, right? Number one. Number two, nothing has been stayed. The survey will go on.
Absolutely. So this is a very important part that you have raised. What Mr. Ahmadi today said in the Supreme Court was that you strike down the survey and you strike down the order, and the survey should be stopped and the plea should be thrown out. However, the Supreme Court said it is not for us to decide the maintainability of a plea, but they have told the district judge that you now will hear that plea on priority. That is what that point number 4 meant, that the district court is now going to decide that plea on priority. The Supreme Court said that's not for us to decide.
No relief, viewers, no relief. The district judge will now decide this matter on merits. It could go on for a few months. We don't know. Till then, the arrangement remains in place. The shivling will be protected. The wuzu khana will be fenced off. However, the namazis will not be inconvenienced. This is fundamentally what has transpired. As I said, viewers, as I began by saying to you, the Muslim side tried and tried and tried to bring this survey to a halt. It hasn't happened. Thank you, Padmaja. Let me go back to the guests very quickly, viewers, and let's go back to all these people who have been misleading us. Zeba Yasmeen, Samajwadi Party. Yes, before that, Ishkaran Bhandari wants to make a point on law. Yes, after having heard the order. Yes.
Point. They wanted specifically, they argued that the survey is void ab initio. The court has not held that. They said all orders, the survey, everything has to be jumped. The court has not jumped that. So Order 7, Rule 11 now will go into what the evidence from the survey came out. That is very vital.
And what is going to be, viewers, when it means maintainability, what is going to be decided by the district judge? Survey of Gyanvapi, whether that is maintainable or not. So no, you remember, viewers, what Talha Aamir was saying to us when he began? He said, because the survey had happened, there was no stay on the survey. No, the matter of the survey is still going to be considered. Talha Aamir, you have been exposed. Sorry. Should Mosque survey be extended?
Please don't misinterpret the judgment.
Oh, yeah.
Don't misinterpret the judgment.
Oh, right. Okay, sir. It's written there in black and white. There is nothing left to imagination.
I can quote the observation. I can quote the words of the Supreme Court. If you want, I can quote the words. It clearly mentions here, your submission overlaps with the Order 7, Rule 11 application. Our difficulty is that to accept that argument will have to comment on the maintainability of the suit, which has to be decided. which has to be decided. Their argument is that
yes, which has to be decided, sir. आप खुद ही पढ़ रहे हैं. अब आप खुद ही अटक रहे हैं.
There's already an application pending in the civil court.
Talha Aamir साहब, give it up, sir, give it up. अब तो order भी आ गया है, अब तो छोड़िए. चलिए,
The civil court has
कोई
to
बात
dispose
नहीं.
of that application.
Fair enough, sir. You're not a lawyer. Please don't try to be someone that you're not. Please, sir. You're not a lawyer. Let me bring in Rizwan Saab. Rizwan Saab.
I am a lawyer, please. I am already a lawyer.
Well, sir, you're a great lawyer. Great. Good for you, sir. But I'm sorry you're way out of your depth. Rizwan Ahmed, please. Rizwan Ahmed wants to come in. I'm bringing Nupur Sharma right after that. Rizwan Ahmed, yes. Rizwan Ahmed.
Yeah, Rahul, Mr. Talha opened the argument कि ये देश law से चलेगा या आस्था से. Let me explain him patiently that what is आस्था and what is a law. And I will quote a Muslim आस्था. तलहा भाई, हमारी आस्था है कि हजूर मोहम्मद सल्लल्लाहु अलैहि वसल्लम जेरूसलम से मिराज पर एक पत्थर से उठे थे. अब यहाँ पर दोनों पाते हैं तलहा भाई, वो आसमानी सफर पर उठे थे या नहीं उठे थे ये आस्था है, लेकिन जिस पत्थर से उठे थे वो टेंजिबल एविडेंस है. काशी में आस्था का आर्गुमेंट नहीं है. काशी में द आर्गुमेंट इज कि दैट प्लेस इज अ मंदिर और अ मस्जिद. दैट इज अ टेंजिबल आर्गुमेंट वेयर यू कैन सी फ्रॉम योर आईज दैट वेदर इट इज अ मस्जिद और अ मंदिर. So don't bring Astha in between. The Gyanvapi case has nothing to do with Astha. Nothing. It is a civil suit based on tangible evidence. अच्छा ये बताओ तुमने लॉ की कहाँ से, ये बताओ. अरे तुमने लॉ कहाँ से की है प्रभु, ये बताओ. तुमने लॉ कहाँ से की है प्रभु, ये बताओ.
आप कौन है सर सर्टिफिकेट देने वाले? Whether he is a Muslim or not, who are you? Now Aamir साहब, आपने मुझे खुद बोला था at the beginning of the debate, let someone finish the point. You yourself said, let me finish my point. Whether am I right or wrong, you can contradict me. Let Rizwan Ahmed speak. No, you will not allow him to speak, is it?
Let him speak on the topic of the debate.
He is speaking on the topic. If you listen to him.
No, he's preaching
He's
to sum up my argument, Rahul.
No.
Rahul, to sum up my argument.
आप क्या करेंगे सर?
Argument, Ishkaran and
उनका सर तन से जुदा करेंगे आप? Will you do that? You want to behead him? Let him speak.
Rahul,
don't be intolerant.
Rahul.
देखिए साहब, 1 minute. I am lowering his fader. This is not right. You yourself prayed. You said that allow me to speak and make my point, even though you were speaking absolute, I'm sorry to say, sir, inaccurate facts. I allowed you to speak and then I corrected you on facts. Now the order is out. You don't want to accept the order. It's fine. You don't have to. It's okay. The debate is a larger question here. Be accommodating at least. But when someone else is speaking, you want to shut them down. You say, I will not accept it. What kind of Democrat are you? What kind of law-abiding citizen are you? Freedom of speech and expression is a freedom guaranteed by the law of this land. Shut him down, please. Lower his fader, Nizam Bhai. This gentleman is passing comments also on who's a Muslim and who's not a Muslim. This is not right. Yes, go ahead. 1 second. I want to bring in Nupur right after. Yes, Rizwan Ahmed, make your point. Finish your point.
Rahul Bhai, Ishkaran and Nupur will agree with me that as a lawyer, if the opposite party is making an argument which is running into ours, that the other lawyer will keep shut and only keep on noting the points. और ये अपने आप को वकील बोलते हैं जिनमें 5 मिनट का नहीं 30 सेकंड का पेशेंस नहीं है इनमें. इनको ये नहीं पता होगा कि वकालतनामा पे साइन कैसे करवाया जाता है और बता रहे हैं मैं लॉयर हूं. शर्म आनी चाहिए आपको. लॉयर की ये तमीज होती है.
Let's not make this personal. Forget it. Sir, you don't have to respond personally to this gentleman. He has tried to get under your skin and completely defray this debate. Let's not do that. Nupur Sharma, I want to bring you in. The charge against the BJP made by this committee and Ahmadi, who was arguing for this committee, is that you're creating a narrative.
Rahul, good evening to you, to co-panelists and also to viewers. There are 3-4 short points I want to make. As far as this Ulema Council's lawyer, God knows where he got his law degree from, is concerned, Did you pay attention how he started by saying that the rule of the law should be upheld? Not ye aastha se desh nahi chalega. But at the same time, within 25 minutes, he actually dropped down to declaring whether Mr. Rizwan is actually a Muslim or not. तो किस तरीके से कानून से बात शुरू हुई और धर्म पे आके अटक गई, सबने देख लिया. पॉइंट नंबर 2, मेजॉरिटेरियनिज्म की बात करी. बताइए, कानून से देश चला था, आस्था से? जब शाह बानो के जजमेंट के बाद किस तरीके से पार्लियामेंट हैड टू नील डाउन, द राजीव गांधी गवर्नमेंट हैड टू नील डाउन, और शरर बानो फॉर दैट मैटर, इवन अयोध्या जजमेंट, हाउ you and the likes of you rather openly threatened the discretion of the Honorable Supreme Court. There have been umpteen such instances. But हाँ, कानून से आज देश चल रहा है, तो कृपया करके आदरणीय सर्वोच्च न्यायालय की सूझबूझ के ऊपर उंगली ना उठाइए. पॉइंट नंबर 3, you know, सेक्शन 242 पढ़ लिया, सेक्शन 4 सब प्रोविजन 3 प्रोवाइजो ये तो पढ़ लेते, तब तो पता चलता कि कानून है क्या असलियत में. पॉइंट नंबर 4, हर वकील को पता होता है राहुल, ऑर्डर 7 रूल 11, द पिटिशन, द एप्लीकेशन ऑफ मेंटेनेबिलिटी इज एक्चुअली डिसाइडेड फर्दर. मेंटेनेबिलिटी डिसाइड होगी तभी तो मेरिट्स पे केस जाएगा. तो कोई बहुत ज्यादा कोई फैंटास्टिक ऑब्जर्वेशन नहीं दिया, ऐसा होता ही है. Because maintainability is usually decided before the case can be argued on merits. And most importantly, what did you miss, Rahul? Did you miss that Mr. Owaisi's language was the same as Mr. Ahmedi actually used before, or rather employed before Justice Chandrachud today? He also said, my plea is all this exercise needs to be nipped in the bud. And this exactly was not allowed by Honorable Mr. Justice Chandrachud before the Honorable Supreme Court. Their main prayer was to dismiss the survey or stay the survey. Their main prayer was to dismiss the suit in toto. It wasn't allowed. And forget us, it is private worshippers. And I'm just going to say one last thing and a food for thought, which Rahul, you may find interesting. 1991, this Places of Worship Act was passed, a political gimmick rather. And before that, Shringar Gauri Puja was allowed every day, more regularly and frequently rather. After this act was passed by Narasimha Rao government, in 1992, Mulayam Singh Yadav, furthering the political agenda, put a stop, in fact limited the prayers offered to once a year. Now please tell me and pray tell me, under the Instant Places of Worship Act 1991, isn't the order passed by the Mulayam Singh government in violation of the 1991 Act itself? Does not that change the very character of offering prayers of Shringar Gauri in the Gyanvapi Parisar?
Well, that is a valid point. I have to concede.
I need to respond.
I have to, no, 1 second. Talha Aamir sahab, let the others also speak. दूसरे लोग भी आए. आप भूल गए होंगे, थोड़ा टॉलरेंट भी होइए. ज़ेबा यास्मीन मैडम भी हैं, इमाम एसोसिएशन के हमारे बहुत अच्छे प्रवक्ता भी हैं, वो भी बैठे हैं. राशिदी साहब, उनसे भी थोड़ी बात कर लेते हैं. ज़ेबा यास्मीन, the time has now come perhaps to be accommodating. The matter will go on. We already know what the survey is saying. The maintainability of the survey is not really in question, because on a very fine point of law, Justice Chandrachud, and you are live tonight at 8:30, madam. You have read the order. On a fine point of law, Justice Chandrachud has come out and made a point. He said there are hybrid nature of places of worship and not unknown in India. Ascertainment of religious character of a place is not a violation under Section 3 of the 1991 Act. Direction एक किस्म से मिल गई है. And therefore the district judge is unlikely to say anything different or ever different from what Justice Chandrachud has said in this hearing. So Zeba Yasmeen, we know perhaps what will happen. Why don't you allow the petitioners to worship? क्या जाता है?
See, Rahul, a very sweet gesture of yours. Why don't you allow, as if I am going to allow here only? But see, when two parties, they go to the court, obviously they have differences. That is why they are going. And then we expect one of the party to adjust and compromise before the verdict comes. How is it possible? It's not at all possible. When two parties are fighting in the cause, they do not accept each other's point until the verdict comes. This is the fight. So I guess both the sides should be heard by the court.
Zeba Yasmeen, madam, आप हिस्ट्री भूल गई हैं? 1992 तक, टिल 1992 द वर्शिपिंग वाज अलाउड एवरी डे। बदला इसीलिए क्योंकि कांग्रेस सरकार ने थोड़ी गेम खेली। समाजवादी पार्टी जो आपकी पार्टी है, उनके जो मुख्य हैं, उन्होंने डिसाइड कर दिया जो कांग्रेस कह रही थी हम एक्सेप्ट कर लेते हैं। क्योंकि आपके जो लीडर थे, ही वाज नोन बाय द नेम ऑफ मौलाना। नहीं, आपके जो लीडर थे उस दफा तुष्टीकरण की राजनीति में माहिर थे। He was only out there appeasing people. And let me tell you, Miss Yasmin, he was called Maulana Mulayam for this reason. So why don't you give the space to another community to do their thing? That is what a secular democracy is all about.
So Rahul, that means 1991 से अभी तक what Mulayam Singh ji was doing, what Congress was doing, Supreme Court had no role. This is what you want to say?
It had no role. The parliament passed a law. Do you know?
It was helpless, disabled.
Madam, the Supreme Court has no role in what the parliament does unless you challenge the law. ये तो basics है. हमारे देश में there is something called separation of powers.
Everybody had, whatever was being done, everybody had a right to oppose. It is always there, whosoever governments is there.
But it wasn't opposed. Now it has been opposed.
No, so we have no problem.
So why don't you go back to precedent? There is a precedent.
We have, if somebody is opposing,
viewers,
we have
now listen
no
to me.
problem.
Viewers, 1 minute. Let me tell you this.
Decide.
This is really interesting. I was reading some articles today written by some Latvian journalists, lobbyists, call them what you want to. Viewers, you know what they were saying? The Mathura, you see, temple. That case is going back on a 1968 agreement between the two parties. So agreement is okay there in 1968 with regards to the Mathura Eidgah Masjid Rao. But here agreement is not acceptable. Look at the double standards, viewers. This is what I'm saying. You want to uphold an agreement between communities in that Mathura issue, but here you don't want to agree between two communities, even though there is precedent of an agreement between the two communities. Muslims allowed Hindus till 1992 every day to come and pray to Gaurima Shingar. There's no problem.
India is, this unity, India is known for this unity only. And
so then show the unity, be magnanimous.
Let me.
मौलाना साहब, मैं आपसे पूछ रहा हूँ, इमाम काउंसिल के आप, एसोसिएशन के आप चीफ हैं, स्पोक्सपर्सन हैं. Let me ask you. हिंदुओं को आप अलाउ कीजिए. 1992 तक वो बेचारे आते थे वहां पर, क्या प्रॉब्लम है?
मैं कौन होता हूं अलाउ करने वाला, या आप कौन होते हैं अलाउ करने वाले?
देखिए साहब,
ये तो कोर्ट डिसाइड करेगा ना.
अरे 1992 तक तो आपने अलाउ किया था.
दो चीजें सुनिए. आपने मुझे 35 मिनट के, अरे मैंने नहीं अलाउ किया था.
30 साल बाद इतनी नफरत.
सुनिए बात.
ये क्यों?
दो पॉइंट सुनिए. आप मुझे 2 पॉइंट सुनिए. 2 पॉइंट सुनिए. नफरत क्या है क्या नहीं है उसको छोड़ दीजिए. नफरत तो जो फैल रहा है और फैला रहा है वो सब दुनिया देख रही है. दो पॉइंट सुनिए. एक तो याचिकाकर्ता ने इस अपनी याचिका के अंदर इस बात को एक्सेप्ट किया है कि ये मस्जिद है, लेकिन इसका जो वक्फ में रजिस्ट्रेशन है वो रजिस्ट्रेशन गलत है. याचिकाकर्ता ने इसको माना है. नंबर 1. नंबर 2, 1937 में दीन मोहम्मद वर्सेस स्टेट का केस आप पढ़िए. उसका जो जजमेंट है, उसका जजमेंट है कि ये मस्जिद हनफी वक्फ बोर्ड की है. सालों साल से इसमें नमाज हो रही है और यहाँ पर उर्स भी होता है. ये 1937 का फैसला है. दूसरी बात, 1991 में जो एक्ट आया, आज जो सुप्रीम कोर्ट ने उस पर एक टिप्पणी की है और ये कहा है कि भाई इसको डिस्ट्रिक्ट जज सुनेगा 1991 का,
नहीं,
कि ये मस्जिद उसके अंदर आती भी है कि नहीं आती.
You have got it completely wrong. ये गलत कह रहे हैं आप. 1991 का एक्ट तो कहीं है ही नहीं.
मुसलमान हार गए.
आप सर गलत टोपी पहन रहे हैं आज. आप लॉयर की टोपी ना पहनिए. आप उलेमा काउंसिल के हेड हैं, आप इमाम एसोसिएशन के हेड हैं, आप वही टोपी पहनिए. डोंट ट्राई टू एक्सचेंज योर कैप्स. आई एम सॉरी टू से. गलत टाइम मत वेस्ट कीजिए सर. मैंने आपसे एक छोटा सवाल पूछा. अभी भी आप मैग्नानिमस हो सकते हैं.
आप अपनी थिंकिंग को देखिए. आपकी थिंकिंग इतनी गंदी है कि आप जो है गालियां दिलवा रहे हैं लोगों को बिठा के। इतनी गंदी सोच है आपकी। ये आप जर्नलिज्म कर रहे हैं।
गालियां क्या दिलवा रहे हैं?
शर्म नहीं आती?
You are wearing, sir, the hat of a cleric and you are speaking like a lawyer. That's all I'm saying. What is the problem there?
और आप लोगों को गालियां दिलवा रहे हैं।
आप यहाँ लेक्चर मत दीजिए, आप यहाँ काम की बात कीजिए। If you don't want to have if you don't want to debate on the point, don't debate on the point. But don't come here and pull things. I'm sorry, sir. आपको कोई यहाँ एक पॉजिटिव पॉइंट बनाने का, आपको कोई यहाँ पर, you don't have one point to make which is positive. Don't give me lecture on journalism, sir. I've asked you a question. You can't answer a question. Maulana Sajid, Rashid, you want to fight? You can fight, but I'm not getting engaged in this fight. I'm lowering a fader. I want to quickly go across to Ishkaran Bhandari on a point of law. Mr. Bhandari just clarified to these individuals who are constantly coming out here and misrepresenting facts, trying to be who they are not. Each one of them aspires to be a lawyer. Make the point.
One person will play a victim card, the other person will say an outright falsehood. Nobody on this debate has abused anybody. Maybe the arguments were sharp, but there was no abuse. Let us be very clear. There was a specific argument made that all the orders, including the order appointing an advocate commissioner, the order which gave a survey, everything had to go because Places of Worship Act barred it. These were specific arguments. The order you have put it on the screen, the order speaks for itself. The court did not agree with it. The district court will decide as per law. And also one more point, the language used in that is to decide Order 7, Rule 11 on priority. It has not said that Order 7, Rule 11 be decided first. Priority and first are what is the priority? We will see what happens in the district court. And lastly,
you can make all the presumptions and assumptions about the observation of the Supreme Court as per your own convenience.
And lastly, I'm saying one thing. It's a simple English. Please understand English. Read the word language used in the order. And
yes. Now, after teaching me law, you are going to teach me English. Someone was teaching me religion, you are teaching me law, someone will teach me English.
The last thing here is that they have made a statement that once the case comes to court, only after the court order does a party obey it. No, very often parties mediate the matter and settle the matter if they want to settle it. If they want to contest it, they should. The court orders will come. But it is wrong to say that once the case starts, it's never mediated.
Well, let me tell you, viewers, it's quite simple. From the responses that you've heard, this is going to be a protracted, bitter fight in court. It can all be avoided. There are two routes. The central government can either reappeal the 1991 Act, and I wish they would, but they won't do that. Or, viewers, the two sides can sit down and say, let's go back to the 1992 situation where the Hindu side was allowed to worship. Till then, there was no problem. But politics was played. The Hindu side was deprived of its right. Then came in an act of parliament which was thrust in everyone's face. And the Hindu side went back to going to this particular place for their worship just twice a year, viewers. Today the Hindu side says, restore our rights. We only want to worship. We don't want your mosque. We are not taking it over. Just want to worship. But it is not acceptable. This is tolerance, viewers. This is a definition. One-way street.